Well, Elon Musk's lawsuit against Alameda County is over.
That was fast.
Viva Frei, Montreal litigator turned YouTuber, and you may recall that on May 18th, I did a vlog about Elon Musk's lawsuit against Alameda County. It was a motion for injunctive and declaratory relief against Alameda County, seeking an order declaring their lockdown orders to be unconstitutional and an injunction enjoining them from enforcing their lockdown orders against Tesla. It was an interesting lawsuit. It raised interesting legal questions. I was excited to see how the court would rule on those questions, but it seems that Tesla's threat to leave the state sort of forced the parties to sit down and come to their own agreement. From The Verge, Tesla drops its lawsuit against Alameda County over lockdown order. The company did not provide any reasoning for dropping the suit. The caption under the headline says that Tesla did not provide any reasoning for which it dropped the lawsuit, but if you read the actual article, it says that they came to an agreement with Alameda County about the reopening, so it's pretty clear why they dropped the lawsuit. Tesla voluntarily dismissed its lawsuit against Alameda County without prejudice, according to documents filed in a California court Wednesday, but the company did not provide any reasoning for why it was dropping the suit. The electric car maker sued the county on May 9th amid Tesla CEO Elon Musk's war of words with county officials over the shuttering of his company's manufacturing facility in Fremont, California. County officials later approved Tesla's reopening plan, despite the company having already reopened in violation of county orders, and things seem to have de-escalated. But Musk is still actively casting about for a new factory location, and several states are said to be in the running. Now, I am no mind reader, but given the fact that the county approved Tesla's reopening plan, I don't think we need them to specify why they were dropping the lawsuit. Once the county approved Tesla's reopening plan, the lawsuit basically became without object. Only a stubborn and overly litigious plaintiff would continue the lawsuit just to prove a point that they were right on the merits. Alternatively, perhaps the plaintiff did not feel strongly in the merits of the lawsuit and they filed the lawsuit as a pressure tactic to come to an agreement. But at the end of the day, lawsuits are weapons used in what we refer to as lawfare, and it seems that the risk and cost of litigation, coupled with the threat of Tesla actually leaving Alameda County, was enough to bring the parties to the table to come to an agreement on their own. And although we will not get a judgment on this lawsuit, the Supreme Court of the United States recently came down with a judgment in the South Bay Pentecostal Church that would give us an indication as to where they might have gone with this lawsuit. We'll get to that decision in this vlog, but first, something interesting in the voluntary dismissal of Tesla's lawsuit. Pursuant to Federal Rule of Civil Procedure 41A1, capital A, lowercase I, Plaintiff Tesla Inc., by and through its undersigned counsel, hereby dismisses its complaint in case number 420 CV03186 without prejudice. This is not a dismissal with prejudice, meaning that Tesla would not be able to refile in the future. This is a dismissal without prejudice, meaning that Tesla can, if they so choose, if they deem fit, resue on the same basis in the future. So I don't necessarily read this voluntary dismissal as being something of a moral victory for Alameda County. The other interesting thing to appreciate is that you don't just get to sue people and withdraw your proceedings if you don't like the way things are going. If a plaintiff decides to withdraw their proceedings, they can nonetheless be held on the hook for certain costs incurred by the defendant. So if a party wants to withdraw its proceedings without potentially being held on the hook for certain costs to the opposing party, it does require the consent of the other party. In this particular case, although Tesla did not provide any reasoning for why it was dropping the suit, it's obvious the parties came to a mutually acceptable agreement. The objective of the lawsuit had been reached. There was no further purpose for the lawsuit. We will never know how the courts would have adjudicated upon this claim, but a recent decision from the Supreme Court of the United States gives us a pretty good indication as to where the courts probably would have ended up. Supreme Court of the United States, South Bay Pentecostal Church et al. Versus Gavin Newsom, Governor of California et al. On application for injunctive relief. The application for injunctive relief presented to Justice Kagan and by her referred to the court is denied. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would grant the application. Chief Justice Roberts concurring in denial of application for injunctive relief. Just a little aside, this is where law and politics collide. It would seem that Justice Roberts is now the swing vote on issues that seem to be partisan legal questions. What is the legal question in this particular lawsuit? Well, it is somewhat analogous to the questions that were raised in Tesla's lawsuit. So by now, I take for granted that everybody on Earth is familiar with the fact that we are living through the My Sharona Cyrus Schmandschmendrick, which has led to certain government lockdown orders. For those of you who might be new to the channel and have no idea what I am talking about with the My Sharona Cyrus Schmandschmendrick, that is the nickname I have given to COVID-19. Although we are allowed to use the word COVID-19 on YouTube without our videos being automatically demonetized, I have sort of grown a liking to my Sharona Cyrus Schmandschmendrick. As a result of what has been going on around the world, the governments of the world have been enforcing lockdown orders of varying degrees of severity. Even within certain countries, provinces, states, and even counties have been enforcing their own specific lockdown orders. And in California, Governor Gavin Newsom had prohibited church gatherings altogether for a certain period of time. The South Bay Pentecostal Church sued Governor Gavin Newsom over the prohibition, and even after Governor Newsom allowed the church to reopen at 25% capacity, they nonetheless pursued with their lawsuit. Under the reopening plan, the church was allowed to reopen at 25% capacity, which they didn't think was fair application of the law, given that other businesses were allowed to reopen at 50% capacity. The church's lawsuit was initially dismissed by a judge. That dismissal was affirmed by the Ninth Circuit Court of Appeal, and then it went all the way up to the Supreme Court. And for those of you who have been around my channel long enough, you know that I oftentimes talk about Scott Adams' idea of one screen, two films. I'm actually not sure if it's originally Scott Adams' idea, but I often talk about the one screen, two films. Well, now you are going to witness the legal manifestation of that same principle. One lawsuit, two judgments. We literally have one Supreme Court of 9 justices looking at the exact same lawsuit and coming to 2 diametrically opposing conclusions. The governor of California's executive order aims to limit the spread of myshrotavirus, a novel, severe, acute respiratory illness that has killed thousands of people in California and more than 100,000 nationwide. At this time, there is no known cure, no effective treatment, and no vaccine. Because people may be infected but asymptomatic, they may unwittingly infect others. The order places temporary numerical restrictions on public gatherings to address this extraordinary health emergency. State guidelines currently limit attendance at places of worship to 25% of building capacity or a maximum of 100 attendees. I know a ton of people out there must be screaming at their computer screens, where is the court getting its facts from? What expert evidence is the court relying on? I don't know. All that I know is that this is the opinion of the court, and when it comes to law, this is the only opinion that matters. Applicants seek to enjoin enforcement of the order. Quote, such a request demands a significantly higher justification than a request for a stay because, unlike a stay, an injunction does not simply suspend judicial alteration of the status quo, but grants judicial intervention that has been withheld by lower courts. And that request was dismissed by the first judge, dismissed by the Court of Appeal, and dismissed by the Supreme Court. But let's get right into the one lawsuit, two judgments, because it's actually quite mind-blowing. Although California's guidelines place restrictions on places of worship, those restrictions appear consistent with the Free Exercise Clause of the First Amendment. Similar or more severe restrictions apply to comparable secular gatherings, including lectures, concerts, movie showings, spectator sports, and theatrical performances where large groups of people gather in close proximity for extended periods of time. And the order exempts or treats more leniently only dissimilar services such as operating grocery stores, banks, and laundromats in which people neither congregate in large groups nor remain in close proximity for extended periods. Here we see the majority of the SCOTUS that wants to dismiss the lawsuit, what they consider church services to be similar to and dissimilar to. The majority considers church services to be similar to lectures, movie theaters, spectator sports, but dissimilar to laundromats, banks, and grocery stores. And this allows the majority to come to the conclusion that the church is getting the same treatment as these other similar services and explains why they're getting different treatment than the other dissimilar services. And on the question of the justification in the first place, the majority writes as follows. The precise question of when restrictions on particular social activities should be lifted during the Schmandschmendrick is a dynamic and fact-intensive matter subject to reasonable disagreement. Our Constitution principally entrusts, quote, the safety and the health of the people to the politically accountable officials of the states, quote, to guard and protect. When those officials, quote, undertake to act in areas fraught with medical and scientific uncertainties, their latitude, quote, must be especially broad. Where those broad limits are not exceeded, they should not be subject to second-guessing by an, quote, unelected federal judiciary which lacks the background, competence, and expertise to assess public health and is not accountable to the people. That is especially true where, as here, a party seeks emergency relief in an interlocutory posture, while local officials are actively shaping their response to changing facts on the ground. The notion that it is, quote, indisputably clear that the government's limitations are unconstitutional seems quite improbable. Agree or disagree with their opinion, this is the opinion of the majority of the SCOTUS, and it is the only opinion that matters in law. It also gives us a pretty good idea as to where the courts would have gone with the Tesla lawsuit, because this reasoning applies to the state as much as it applies to each individual county. Now let's get into the dissenting opinion, which is a totally different judgment on the exact same lawsuit. Justice Kavanaugh, with whom Justice Thomas and Justice Gorsuch join, dissenting from denial of application for injunctive relief. I would grant the church's requested temporary injunction because California's latest safety guidelines discriminate against places of worship and in favor of comparable secular businesses. Such discrimination violates the First Amendment. Can we just appreciate how amazing this is? We have 9 of the greatest legal minds in the country looking at the same set of facts and coming to 2 diametrically opposing conclusions. The majority says the church is being treated similarly to similar businesses, therefore not violating the First Amendment. The minority says the church is not being treated similarly to similar businesses, therefore violating the First Amendment. And you know sure as sugar that whatever divide we see in the Supreme Court, we're going to see a similar divide in the nation, both sides thinking that they are right. In response to the My Sharona Cyrus health crisis, California has now limited attendance at religious worship services to 25% of building capacity or 100 attendees, whichever is lower. The basic constitutional problem is that comparable secular businesses are not subject to a 25% occupancy cap, including factories, offices, supermarkets, restaurants, retail stores, pharmacies, shopping malls, pet grooming shops, bookstores, florists, hair salons, and cannabis dispensaries. I know which side I tend to agree with, but I'm curious to know which side you tend to agree with. Alright, I'll tell you, I tend to agree with the dissenting opinion.
There, I said it.
South Bay United Pentecostal Church has applied for temporary injunctive relief from California's 25% occupancy cap on religious worship services. Importantly, the church is willing to abide by the state's rules that apply to comparable secular businesses, including the rules regarding social distancing and hygiene. But the church objects to a 25% occupancy cap that is imposed on religious worship services but not imposed on those comparable secular businesses. Now, for those who disagree with this dissenting opinion, I know what you're thinking, that you cannot compare secular to non-secular businesses. By definition, secular and non-secular businesses are dissimilar and therefore could justify dissimilar treatment. But as far as I am concerned, the important distinction is not the nature of the business as secular versus non-secular, but rather the nature of how the business is conducted. The interaction of the patrons, the proximity of the people to one another, the duration for which that proximity is maintained. If factories, offices, and restaurants are only limited to a 50% capacity, it doesn't make any sense that a church should be limited to a 25% capacity. In my view, California's discrimination against religious worship services contravenes the Constitution. As a general matter, the quote, government may not use religion as a basis of classification for the imposition of duties, penalties, privileges, or benefits. To justify its discriminatory treatment of religious worship services, California must show that its rules are, quote, justified by a compelling governmental interest and, quote, narrowly tailored to advance that interest. California undoubtedly has a compelling interest in combating the spread of the My Sharona Cyrus and protecting the health of its citizens. But, quote, restrictions inexplicably applied to one group and exempted from another do little to further these goals and do much to burden religious freedom. What California needs is a compelling justification for a distinguishing between 1. Religious worship services and 2. The litany of other secular businesses that are not subject to an occupancy cap. California has not shown such a justification. In sum, California's 25% occupancy cap on religious worship services indisputably discriminates against religion, and such discrimination violates the First Amendment. I would therefore grant the church's request for a temporary injunction. I respectfully dissent. It is an amazing thing. California has said that certain businesses can reopen, but they have to reduce capacity to 50%, whereas this church, for some reason, has to reduce their capacity to 25%. And the majority of the Supreme Court of the United States rationalizes and justifies this decision, where the minority does not. 1 screen, 2 films, 1 lawsuit, 2 judgments. Alright, and that is the vlog. If you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below. Let me know if you agree or disagree with this decision and why. If you want to support the channel, all of the support links are in the pinned comment. But above all else, take care of yourselves, stay safe, stay healthy, and now you know your vlog. Peace out.